Hi, everyone, and thank you for joining us today for Substitute Decision Makers, an overview for EMT coordinators. I'm Marty Washington. I want to just take a moment to thank our funders from the Office for Victims of Crime for funding not only this presentation, but for the EMDT grant, and remind you that the recommendations, conclusions, thoughts that you hear about today are those of the author and not necessarily the Department of Justice. As far as housekeeping, please, if you could mute yourself if you're not talking, that helps cut down on background noise. Make sure that you've renamed your square if it doesn't have your name on it. Use the chat feature if you have a question. And if you have any technical assistance issues, please reach out to me at mwashington@ncall.us. And with that, I'm going to turn it over to our speaker today, Ann Laatsch. Ann?
Hi, everybody. I am Ann Laatsch. I am the Justice System Coordinator for NCALL, and I work with our grantees on anything related to the justice system. So I'm happy to be here. Thank you for the invitation. And I love that it's a small group. So if you have questions as I'm going along, feel free to raise your hand or pop it in the chat. Marty is going to be keeping an eye on that. And if there's anything you want to talk about more or whatever, just let me know. But I appreciate you being here. This is one of my favorite topics just because I'm a nerd like that. So hopefully by the end of this, it'll be one of your favorite topics. So today we're going to, by the end of this, you should be able to talk about some of the key features, benefits, and risks of common substitute decision-making tools that we're going to go through today. Talk about some common issues related to how MDTs review cases with substitute decision makers. And then you'll be better prepared to create policies and procedures within your own EMDT related to cases where a substitute decision maker was involved. And just a quick overview of the content that we're going to be covering today. We'll talk about the most common forms of substitute decision-making tools, powers of attorney, guardianship, conservatorship, and then a little bit on supported decision-making. What are the implications for EMDTs? What are some practice tips for EMDTs? And then I'm happy to answer questions at the end too. So supported decision-making, we're going to just talk about the most common kind. Oh, I have to move this. Hold on one second there. We're going to be talking about the most common kinds of substitute decision-making options. So first, there are legal instruments and court procedures by which individuals may have somebody else making decisions for them. Those can include documents like a healthcare power of attorney, a financial power of attorney, which could also be called a durable power of attorney for finances. They also include guardianships, which some states call guardianship conservatorship. In other jurisdictions, guardianships and conservatorships are separate legal entities. For example, in Wisconsin, where I am, conservatorship just refers to a financial authority rather than a more comprehensive authority. The common denominator with all of these is that in each case, the adult has another person designated to make decisions about their life. We're also going to talk super briefly about supported decision-making, which is a less restrictive alternative to guardianship that allows individuals to retain control over their life choices, but still getting necessary support that they might want. Before we get into more detail, I think it might be helpful to review some common legal terms that have specific meanings within the context of substitute decision-making. So proxy and agent can mean the same thing. Sometimes people refer to a document as a proxy, and sometimes they refer to the person as the proxy. But basically it's, excuse me, a written instrument that is authorized to act on somebody else's behalf, or giving authority to act on someone else's behalf. Authority to act as an agent or a proxy must be granted in writing I just can't say, okay, Marty, can you go do this to me because I'm designating you my power of attorney. Would not hold water. But if a principal executes a healthcare power of attorney document to appoint someone as their agent, that means they've executed the necessary paperwork, and that can also be called a healthcare proxy. In guardianship cases, however, the person who's under guardianship is called the ward, and obviously the guardian is called the guardian. Any questions about terms at all? Okay. An E-MDT can very well be well positioned to address abuse by a proxy for a few reasons. First of all, happily, E-MDTs are becoming more widely available. And as we know, multidisciplinary collaboration is key to increasing victim safety and offender accountability. Some MDTs have a particular focus on abuse by a proxy and have strong records of addressing this issue. And the very existence of an E-MDT in a community can create opportunities for awareness raising, creating an environment where people are more attuned to identifying and responding to proxy abuse. Also, collaboration among key systems is obviously a critical part of your work, and that can really translate to improved responses. And finally, E-MDT membership generally includes APS and law enforcement, ideally, who really are on the front lines of this sort of abuse. If it's happening, it's going to be detected by an outsider. It's usually one of those two entities. Some of the challenges for E-MDTs, like why this might be a difficult topic, is or not something that E-MDTs would come across, is unfortunately E-MDTs are not yet available everywhere. Not all of them have this as a particular interest area, or it may not be on their radar, or it may not be something in their community that they have seen a lot yet. And it may be difficult to have consistent representation on the E-MDT from key groups. For example, I know from trying to engage law enforcement in training that, for the last few years, law enforcement agencies have across the board been understaffed, under-resourced, and it can be really difficult for them to commit to things like attending outside meetings. So that can be a challenge. Let's start by talking about what is probably the most common form of substitute decision-making, and that is powers of attorney. Healthcare powers of attorney, I hope everybody on this call has one. You should raise your hand if you have one, because it is really important. Healthcare powers of attorney are the most common instruments by which people appoint a substitute decision maker, and they're certainly not limited to older adults. I would say that anybody who is over the age of 18 should have one. It's a written document that appoints another individual called the agent to make healthcare decisions on behalf of the principal or the person who's designating the authority. I'm going to talk about healthcare powers of attorney, but I want to just quickly touch on the notion of a living will. You may have heard that term, living will. And what that means is, at least in Wisconsin, some states have different terminology, but in Wisconsin, a living will only speaks to particular circumstances. It talks about whether you want the agent to be able to admit you to a nursing home, whether you want life-sustaining measures implemented if you are incapacitated, and who you would want as a guardianship. So it speaks directly to particular issues. A healthcare power of attorney is much broader. It is, when you put one in place, you, the principal, are having a conversation with the agent and saying, these are my wishes. So it's going to cover any circumstance that might arise because that person is designated to speak for you, and they are required to speak for you, and that should reflect what you have told them you want. So the more detail you can give them, the better. So depending on how the power of attorney is drafted, the authority can start immediately, or only when the principal is determined to be incapacitated. it can be as broad or as limited in scope as the principal desires. The agent, as I said, is responsible for making decisions based on the wishes of the principal. So the principal should have really frank and really clear conversations with the prospective agent to make sure that their wishes and preferences are known. Just so if you have questions about the difference between a living will and a healthcare power of attorney, there's lots of information online about that. But I think the biggest takeaway is for me that a healthcare power of attorney is more comprehensive, as long as there's been a lot of communication back and forth between the principal and the agent about what that person wants. Oh, I actually didn't talk about the slides. Yeah, healthcare power of attorney can include decisions related to mental health, institutionalization, medication. I have seen them drafted where somebody will write in the notes section, I only want country music played in my hospital room if I am hospitalized. Like, you can get as crazy as you want. And if you have very specific needs or concerns, that is your opportunity to set them out. So there are a lot of benefits to healthcare powers of attorney, particularly for survivors of abuse. The principal can direct their own medical treatment ahead of time to protect themselves against what might be abusive decisions of a third party. The principal is empowered to elect a decision maker that they want. And they can even nominate a future guardian. I know that my mom has a power of attorney, and she states that if it should become necessary to appoint a guardian, she would want that to be me. Also, families and doctors will know in advance what the principal wants to have done, and they can act accordingly, overriding an abusive partner's objection. And then finally, healthcare powers of attorney are revocable as long as the principal is competent, or has capacity, and that is a medical determination. So it's, everybody should have their spidey senses attuned to a potential abuser and the authority that person might have. I think sometimes when we think about elder abuse, we think, well, what does a healthcare power of attorney have to do with abuse? But when you look at somebody who may be being exploited financially, and the abuser has a healthcare power of attorney, well, what if that person needs expensive treatment and the person, doesn't want to spend the money on that because they're exploiting them? There are a lot of ways that it can be used to abuse. So just have that on your radar. Some of the risks, other risks that we can talk about, even though there are lots of benefits to these powers of attorney, it is giving a lot of power to the designated agent, especially if the principal is incapacitated or is perceived to be limited in capacity. There are some safety measures that can be incorporated into these power of attorney arrangements, but they're hard to monitor and hard to enforce. I know in Wisconsin, you can petition the court to review the performance of an agent, but as I'm sure you can imagine, that is a time-consuming prospect. It is not cheap, and I don't even think it happens very often. If an older adult executes a healthcare power of attorney giving authority to an abusive person, it really can be licensed to exert power and control over the adult's life. Here are some questions that E-MDTs as a group can explore as they prepare to review cases where somebody is being harmed by a substitute decision maker, and there's a healthcare power of attorney involved. In your jurisdiction, in your community, it's good to know ahead of time what safety measures exist in those commonly used forms. For example, in my state, we have a statutory form. Most states do use a standardized form, although it's perfectly fine to pay a lawyer to draw something up that is fancier. It is not necessary usually. So find out what are the safety measures that are built into those forms, what entities or systems are responsible for oversight. So if it were here, I would say you want the courts involved, you want the Department of Health Services involved, hospital systems, that sort of thing. Making sure those folks are at the table if possible. And then thinking about what opportunities there might be for better oversight and better coordination to better prevent these things in the future. And also making sure that all the members of the E-MDT understand how a healthcare power of attorney could in fact be used against somebody or used to harm somebody. Any questions about healthcare powers of attorney? Okay, then we're going to move on to the durable attorney or durable power of attorney for finances. Another common document that you may encounter is the durable financial power of attorney. A financial power of attorney is, again, a written document, has to be written, naming another person, their agent or proxy, to manage legal and financial affairs. The agent or proxy can be anyone the principal chooses. That is super important, obviously, if the older adult spouse or caregiver is abusive. The power of attorney can start immediately or when the principal becomes incapacitated. The benefit of it going into force immediately is that you can help somebody pay their bills. I do that for my mom. And it involves going to the bank and, so you can see their bank accounts and paying for things and keeping an eye on things, but it's easy to see how easy it is to exploit that. Again, just like the healthcare power of attorney, it can be as broad or as limited in scope as the principal desires. It can be drafted to allow for really creative arrangements that empower clients to limit an abusive party's authority to the extent that they feel is necessary. The financial power of attorney is generally durable, which means that when it is executed, the person has to have capacity. They have to be competent to execute this document. And then once they are declared incapacitated, that remains in effect. So you are delegating a huge amount of authority to somebody, and it's going to last a long time. So when you do this, if you haven't already, you want to make sure you're choosing someone who is trustworthy. A power of attorney is a document that can potentially convey a huge amount of authority. And it is recommended for this one that it be drafted by an attorney. Again, there's a statutory form in most jurisdictions available online, and they can be retrieved by anyone. Most of them in this situation require witnessing and a notary. But in order to be able to assess the validity of such a document, it's a good idea to familiarize yourself with the legal requirements in your jurisdiction. My first job after law school was working with older victims of crime in a legal services agency. And every week we would have somebody come in with their mom or their grandma, and they would say, "Hi, she wants to talk to you about a power of attorney for finances." And then I would say, "Okay, I need to speak to her alone." And it would more often than not turn out that it was not her idea, or she didn't even know why they were there, things like that. So it is so common that it's very frustrating to me how common abuse of these documents is. And the reason they are so commonly abused is because they cede a lot of power over the principal's assets. Agents or proxies gain the power to spend the principal's money, withdraw money from their accounts, acquire assets in their name, apply for credit, take out loans, just a ton of things, sell property, enter into contracts, incur debt, pursue insurance claims, pursue legal actions. So it really is a comprehensive authority. Now, the statutory form that we have here and that is common in many jurisdictions has a checkbox. So you have to explicitly designate each authority that you are granting. But very often people just go down and check every box. And it's a very simple act that conveys a ton of authority to somebody else. There are, fortunately, some limitations on the power of the agent. The agent must keep their personal money separate from the principal's money. The agent cannot stand to profit from any transaction that they make on behalf of the principal. And the agent must keep records and provide an accounting documentation upon request of the principal or anyone else asking, acting on their behalf. So like a guardian or somebody like that. They have to be able to show what they have done on behalf of that principal if they are requested. And that begs the question, like, how often does that happen? It doesn't really happen until often until abuse has been going on for a while. A little bit about gifting. Agents can only make gifts of or from the principal's assets to themselves or anyone else if the power of attorney explicitly grants that authority. And the agent cannot violate any other limitation that the principal chooses to include in that power of attorney. So an example of that might be, let's say the agent or the principal every year I send Marty $20 on her birthday. And I'm going to put in my power of attorney that I want to continue sending Marty $20 every year on her birthday. The agent can't all of a sudden get that authority and say, you know what, I think Marty doesn't need that money anymore. I'm not going to do it. Or they can't say, Marty, I'm going to send you, $200 this year, but you're going to give me $100 back or something like that. You have to follow the wishes as they're laid out in that document. Powers of attorney, financial powers of attorney are also revocable if the person is competent. And it's very easy. They can revoke a power of attorney by writing a statement saying, I revoke the authority of Ann Laatsch to act as my agent pursuant to any and all powers of attorney I have given prior to this date. It doesn't have to be fancy at all. They should just sign, date, and notarize it, and then distribute it to anybody who has a copy. So typically somebody who has executed a power of attorney would distribute that to the bank, to family members, to any other entity that they have financial dealings with. That procedure there, just very, very brief revocation, is generally sufficient to revoke a power of attorney, but you should probably consult with legal service providers or private bar, elder law practitioners just to confirm your local practice. And this all is a really good argument. We're going to talk about this more later, for having civil legal representation on your E-MDT also. There are lots of benefits, however, to a financial power of attorney if the agent is a trustworthy person. One of those benefits is that the principal can continue to direct their own legal or financial affairs as long as they are competent. As I said, I'm my mom's agent. I really don't do much, occasionally sign a check, but she's totally able to direct her own affairs, and she does. When the time comes that she needs more help, then this is in place and she can get more help. Another benefit, just like with the healthcare power of attorney, is that the principal has the power to choose the person that they want to be their agent. And then finally, when it prompts a discussion and a sharing of information between the principal, whoever executed the document, and the potential agent, the person who's helping to execute the document, this is why I like to have attorneys do them, can really kind of be aware of what's going on in the relationship dynamics, and is there concern that abuse is happening in this situation. Again, the risks are that there's a huge amount of power being granted to an agent. And if that agent is the wrong person, they basically have a license to exert power and control and to exploit that person. Safety measures do exist, but they are difficult to monitor and difficult to enforce. And again, at least here, it would mean involving the courts, and it would be time consuming. And oftentimes by the time it gets to court, much of the damage has already occurred. So what happens without a financial power of attorney in place? If an older survivor does not have a financial power of attorney and they lose the capacity to make responsible decisions, in an emergency, bills may not get paid. They may get sued because they have outstanding debt. Without a financial power of attorney, a court may have to step in and appoint a guardian or a conservator, and that might not be a person that they want. once that guardian or conservator is appointed, the older adult is going to experience a much more significant loss of independence than they did just with that, had they had a financial power of attorney in place. They're going to lose all legal ability to make decisions for themselves, a loss of independence. And the guardian that they appoint may be someone they wouldn't choose, or it could be a corporate guardian, meaning someone who does that for a living, and it's not really a great personal relationship. So there's lots and lots of reasons that anybody of any age should have one in place. Some questions here related to the power of attorney for finances that E-MDTs might consider. Are you aware of how safety measures are monitored and enforced in your community, in your state or tribal community? Do you have court representation on your E-MDT? I mentioned the importance of having civil attorneys, elder law attorneys around the table. If you don't know in your community who are the prominent elder law folks, there's an organization called the National Association of Elder Law Attorneys. And they have a great directory on their website, and you can search by location. And then does everybody on the E-MDT understand how powers of attorney function and how much authority is granted and how dangerous they can be? I think some folks have the understanding, just like with guardianship, that it's a protective measure. And like, as long as that's in place, everything is cool, when it may very well be problematic or be used to abuse somebody. So we're getting into guardianship now. Does anybody have questions about powers of attorney before I move on? All right. So guardianship. Legal guardianship is another issue that can happen often in cases involving older victims. Guardianship over another person, as you remember, we call them the ward, occurs when an individual becomes impaired to the extent that they lack understanding or capacity to make or to communicate responsible decisions. So it's going to be a pretty severe situation. Generally, an individual is assigned a guardian when they become incapacitated by reason of mental illness or impairment, physical illness or disability, substance abuse, or some other cause. The guardian is required to act in the best interest of the ward. So remember how with the healthcare power of attorney, we talked about how the agent is required to do what the principal told them they want. That is not the case with guardianship. Guardian is required by law to act in the best interest of the ward, not according to their wishes. The important thing here, too, another important thing to know is that guardianship authority can only be granted by a court. It's a term that is sometimes used loosely. I have had situations where someone came in my office and they're like, yep, I'm my grandma's guardian. And you can't just appoint yourself guardian. If you encounter a situation where you're being told that someone has guardianship over another person, ask to see the legal documents establishing that authority, because there have to be some in place. They might be called a guardianship order. It could be called, as it is here, letters of guardianship. But in any case, what's important to know is it can only be granted by a court, and there will be paperwork. I already talked about how in some jurisdictions, what I'm describing as guardianship is also called conservatorship. In some states, conservatorship refers to a voluntary process, so you can kind of put yourself under guardianship. In Wisconsin, we have an additional function that is, you can go to the court and say, I need protection from particular individuals. That's a whole other topic. But basically, there's a lot of terms that come into play within the guardianship world. So it's a good idea to familiarize yourself with what these terms mean in your community and what programs are available to somebody who is in need of protective services. A person who is a legal guardian of someone else has the same powers and rights and duties as a parent to a child. So they are responsible for that individual. The guardian has the power to establish placement of the individual, legal possession of that person's property. They have the authority to make decisions about medical care, treatment, services, sole authority over the person's finances unless there is some other arrangement in place. In some communities, the guardian's power has to be enumerated. That means, just like with the healthcare power of attorney, a box has to be checked on each form to identify the specific authority that's being granted, or rather with the durable power of attorney. And that's how it is in my state. You can't just say I'm taking away every authority that they have, every power that they have, and it's going to me. In Wisconsin, you have to check every box. So maybe you want them to retain the power, the authority to vote, or to get a fishing license, or to have a driver's license. Those are all things that could remain available to them. Often older adults can nominate the person or the people that they would choose to act as their guardian should it become necessary. This can be done with an advance directive like the healthcare or durable power of attorneys that we talked about before. It can also help ensure that the appointed guardian is not somebody who's going to abuse their guardianship power, or that someone who's going to make decisions that are inconsistent with the survivor's wishes or values. Establishing a guardianship can actually be beneficial to survivors of elder abuse. A capable and well-intentioned guardian can protect an incapacitated victim from future harm by a perpetrator. For example, an older victim who is married to an abusive spouse and who does not have any legal arrangement in place may be further victimized by their spouse as they age and they become less able to protect themselves. In that case, the victim can choose a trusted third party, like a sibling or a friend, to be their guardian if they become incapacitated in the future. A good guardian can also pursue perpetrator accountability on a victim's behalf. They can act as their agent, in court, and ask a DA to, or ask, interact with law enforcement, communicate with the DA about potential charges, that kind of thing. They can also request a protection order, a no harassment injunction, all those things on behalf of the victim. They basically stand in the shoes of the victim. But of course, you knew this was coming. On the other hand, there can be serious risks to a victim of elder abuse if an abusive person gains guardianship over the person that they are harming. Establishing legal incapacity results in a serious deprivation of autonomy that is really, really difficult to reverse. Guardianship gives the agent a ton of power. And just like with the durable financial power of attorney, it gives the abusive guardian a license to exert power and control over the victim's life, finances, everything. Safety measures can be written into the guardianship order, but they are hard to monitor and hard to enforce, just like with the powers of attorney. I don't remember now if I put this in a later slide, so I'll just mention it now. In most states and jurisdictions, there is a required review of guardianship. When a guardianship is put into place, for example, in Wisconsin, it's every year that the review of the guardianship's performance and the placement of the guardian has to be reviewed and has to be deemed as appropriate each year. They happen every year. Like, are the courts really backed up? Sometimes they fall through the cracks, yes. But those measures do exist. So it's good to be aware of that. I wanted to just kind of compare and contrast powers of attorney and guardianships because they do have distinct legal authority. In a power of attorney, the principal retains their legal authority as long as they have competency. Whereas in guardianship, the ward doesn't have legal authority generally, because for it to be in place, it has to be shown that they are not competent to manage their own affairs. In a power of attorney, the agent must do as the principal wishes, regardless of their best interests. So, if the principal says, I never want to be forced to eat meat, for example, and the doctors are saying, like, we really recommend that they have some meat in their diet because it would be in their best interest, the power of attorney agent has got to say, nope, that is not what they want, and I'm here to argue for what they want. Finally, in a power of attorney, the agent cannot substitute their own judgment for that of the principals, whereas the guardianship actually requires the guardian to substitute their judgment for the ward's judgment. All right. Just some signs if you're reviewing a case that there may be abuse by an agent or a guardian going on. If you see bills that are not being paid, you see services that are needed but are not being provided, or those services have been discontinued. Maybe a guardian or an agent can't or won't document their expenditures or provide an accounting of what they've been doing with the principal's assets. If a healthcare agent seems to be making decisions that everybody who knows that principal knows they would not have wanted, that should be a red flag. If a guardian is making decisions that are not in the best interest of the ward, I mean, they should be removed as guardian because that's literally their job. And then obviously if a ward or principal exhibits other signs of abuse and neglect that you are all too familiar with. And then some questions that the E-MDT here can take a look at and just think about if you ever, I expect you will encounter situations where you have somebody that has a guardian. So take a look, think about what your current process is for reviewing cases where the guardian's involved. And really have everybody examine their own assumptions, because as I mentioned, they're really, I know before I went to law school, I was like, okay, guardianship is great. That's a great way to make sure that somebody's needs are met and to make sure they're protected if they can't protect themselves. That is a naive assumption to have. And then find out what is your local policy for reviewing the conduct of a guardian. Generally, it is a standardized court form. You go and you fill this out and you ask the court, you say, I think this person is being abused. Certainly APS would have a role to play here. I would definitely, that would be my first call, but find out what local policy is for reviewing the conduct of a guardian. What is the local practice for reviewing the appropriateness of guardianship or placement? Is there a required annual review? Is it every 5 years? How does that work? And then of all the systems that are involved that you've identified, is the E-MDT membership inclusive of those systems that are important? Questions about guardianship? What am I doing on time? Ooh, 20 minutes. No? All right. I have one slide on supported decision-making. Are you guys familiar with supported decision-making at all? You heard about it? It is kind of new. Guardianship can be very restrictive, as you heard. In some cases, it could be too restrictive. And there may be situations where an individual wants to retain control over their life decisions, but they might need some support in doing so. So one alternative has grown out of the disability rights movement, and you might come across it in your work. Supported decision-making is an effective and less restrictive alternative to guardianship that uses a team of trusted friends, family members, and advocates to give people the help that they need to understand the situations that they face and the choices that are before them so that they can make their own decisions. So in contrast with guardianship, where one person makes a decision for another person, supported decision-making allows the individual to make their own decisions, but in conjunction with the team of people that they know and that they trust and who are part of a support network. This kind of decision-making shows great promise for increasing self-determination and improving quality of life outcomes. And while availability for it really depends on where you live, there are a lot of good online tools if you just Google it to help you locate information and resources. There is also a National Resource Center for Supported Decision-Making. And they have an interactive map that you can use to find out what's available near you. I just wanted to bring that up as something that may be in place. I think that in terms of abuse, these kinds of arrangements are good because there's generally a team of people in place to support that person. And hopefully, if there's something going on, one of those folks would catch it. But it isn't something that is very, very common just yet. So because the damage that can be done by an abusive agent or guardian is potentially so fast and extreme, it's a good idea to identify community members who might play an important role in your E-MDT. You want to know where to go if you're working with a victim who's being or who is at risk of being abused by an agent under healthcare or financial power of attorney. If you encounter someone who is under guardianship, there are steps that they can take before something happens to petition for review or removal of a guardian, but those things vary greatly depending on jurisdiction. So familiarizing yourself with local resources and procedures before you actually need them can really save you time, but really is going to make you better able to respond to these cases. So these are just some ideas of folks that you want to make sure that you have around the table in these situations, and to prepare yourself for dealing with these situations. Elder E-MDTs, as you are all aware, play a crucial role in addressing cases of elder abuse, particularly those involving proxies. So just a few suggestions about how E-MDTs can better handle such cases. First, understanding these legal frameworks. Members should have a comprehensive understanding of the legal frameworks surrounding guardianship, power of attorney, other substitute decision-making arrangements that might be present in your jurisdiction. This includes knowing the rights and responsibilities of both the older adult, and the proxy under relevant laws and regulations. Screening and assessment protocols. I think it's a really good idea to develop screening and assessment protocols specifically designed to identify cases where proxies may be involved in perpetrating abuse. This could involve evaluating the capacity of the older adult to make decisions independently, assessing the dynamics of the relationship between the older adult and the proxy, those kinds of things. Providing ongoing training and education to E-MDT members on recognizing signs of abuse, particularly those that are perpetrated by proxies, and understanding the complexities of those relationships is really important. It might include training on financial exploitation or undue influence, or other forms of abuse that are commonly associated with proxies. It's a great idea to foster collaboration between E-MDT members and legal professionals, including elder law attorneys, as I mentioned, prosecutors who are familiar with handling these cases, legal services professionals. They can all really provide valuable insight into the intricacies of legal proceedings related to guardianships and powers of attorney in your community. And then regular case review and monitoring processes to track the outcomes of these cases, and maybe flag proxy abuse cases yourselves. That would allow E-MDT members to look at patterns of abuse and assess the effectiveness of interventions, and then make adjustments as needed. But I'd be really so interested to know if there are E-MDTs that track this specific form of abuse and sort of how responses in their community have changed over time. So incorporating some of these strategies into the E-MDT can really enhance your capacity to effectively identify, assess, and then intervene in cases of elder abuse involving proxies. And I think that, that is ultimately the goal here. So just to summarize, everything that we've talked about today is something that can be so beneficial for people who want or need a substitute decision maker, maybe need a little bit more support or help making decisions or handling their finances or legal matters. But it should always just be a red flag when you see one, because they are known to It's fairly easy to facilitate abuse and exploitation if the authority is given to the wrong party. And that should just be something that when you see one in place, you're automatically checking that out. And then EMDTs can have a really important role to play in responding to this kind of abuse by awareness raising, making sure the right folks are at the table, making sure they are trained in this stuff, and then understanding the different roles of the relevant systems that are related to these documents, these processes, and then coordinating with your CCR when you identify gaps in service or get where these instruments are in play. So that was your substitute decision maker 101. I am happy to answer questions if you guys have any. It was very fast. Oh, see something there. Thanks, Marty. I hope that was helpful. I hope you have no questions just because you're experts now.
And there's a comment from Catherine Thomas, great information.
Thank you.
Mm.
I was going to say, if you think of a question later or something comes up, or you know, in 6 months, remember this and want clarification on something or have a case that's relevant, shoot me an email. I'm happy to assist if I can.
Thank you, Anne. And I will be sending out the slides to you all after this. In addition to the link for a Survey Monkey, if you could share your thoughts, feedback on this webinar, that greatly helps us with future webinars to hear your thoughts. So the link is in the chat, but I'll also send it in my follow-up email. Any other questions for Anne Laatsch?
I don't have any questions, but I appreciate the information about the revoking of guardianship, because I do have a situation where I didn't really know what the person should do besides go to court. So that was
good.
That was really good information.
I'm glad. Thank you.
I particularly appreciated the slide where you put side by side power of attorney and guardianship, because they get muddied up in my mind. So that was a great slide for me.
Oh, good.
Hey, well, seeing nothing in the chat and hearing none, thank you so much for joining us today.
Thank you, guys.
It's your day.
Thank you for having me.
Thank you.